Yeah, it should be on. Can you see me now, Ankit?
Yeah, I can see you.
Okay, great.
Good morning, good afternoon, and good evening to all those present. My name is Ankit Malhotra. I'm the president and the co-founder of the Jindal Society of International Law, and I welcome all of you present over here in very good strength and number, which makes us even more satisfied and happy to have and host you here. Before I introduce our speaker, I would like to speak a few words about the Jindal Society of International Law and the Center for UN Studies, which is the center under which this society is created. The society is the center and the society, of course, are spearheaded by Professor Dr. Veselin Popowski. In my discussions and informal talks with Professor Popowski over the years, this conversation has often come up. And he's often told me that in 1953, the first United Nations Secretary General, Trigov Lee, welcomed Dag Hammarskjöld, the second Secretary General, arriving in New York by saying, "Welcome, Dag, to the most impossible job on this earth." The United Nations has often been criticized and turned into a scapegoat when states have failed to live up to the initial expectations of its founders. But let us not forget what Hammarskjöld said in response. He said, and I quote, "The United Nations was not created to take us to heaven, but to save us from hell." The Center for UN Studies engages in projects studying the history and the traditions, but also takes a transformative approach to research, teaching, social engagements, and having in mind the latest dynamic geopolitical and technological shifts. The Jindal Society of International Law is a student-led initiative under the aegis of the Center for UN Studies and the guidance of Professor Dr. Veselin Popowski. Founded in 2022, the society is an initiative to promote a platform to young international law enthusiasts. The inaugural address and official launch of the society was given on 18th November 2022. It was inaugurated by Herbert and Rowe's Professor of International Law, Jose Enrique Alvarez of New York University, along with the Vice Chancellor, Faculty Coordinator, Dr. Popowski, and a good friend of the society, Dr. Mohan Kumar. This series, the 4-lecture series exploring the ecosystem of international law, builds upon the introduction given to internationalism and international law by the concluded spring lecture series titled Future of Internationalism and International Law. The fall series endeavors to study the different contours of international law. To assist in this study, the speakers will cover and address their respective areas of expertise based upon the years of research and practice. Given the vast ecosystem and engagement of international law in it, the society aims to study the fragmentation and fertilization of various disciplines in this ecosystem. The lowest common denominator in this 4-lecture series is to enhance and provide a deeper understanding of international law through international lawyers. The society, for its members, is a well of knowledge and a quorum of thought-provoking discussions, which will be a resultant of this engagement with experts aimed at exploring the ecosystem of international law. To launch this series and our ambitions even further, we have a very special guest amongst us. This is Ms. Vasuda Sinha. Vasuda Sinha is a senior associate at Freshelds International Arbitration Group based in Paris. Vasuda has an experience in disputes of particular nature in commercial and investment arbitration, cross-border and jurisdictional disputes, and commercial litigation. She has also appeared as a counsel before various tribunals and courts, including the SEC, the ICC, and the ICSID tribunals before, and also the Supreme Court of Canada. Vasuda presents and publishes on a variety of legal topics, including investment arbitration and Canadian law. And one such publication caught my eye and was the reason for which we now have ma'am here with us to talk about a very interesting dispute. This dispute cross-cuts into public and private international law. And before I hand over the floor to ma'am, I would like to offer a small quote which is mentioned from the judgment itself. It is by Justice Abella, who says that private law remedy for breaches of international law norms alleged by the workers may be possible. What this essentially is talking about a cross-cut between public international law and private international law and how it is used in domestic courts. With these words, ma'am, now I hand over the floor to you, and I request questions to keep coming in, and we will weave them into the discussion and look forward to participation from everyone else. Thank you so much. Ma'am, the floor is yours now.
Thanks very much, Ankit, and thanks very much for the invitation to join you here today. You're really gaining a lot of ground with this series that you've launched, and you should be congratulated for it. So as you've alluded to already, there's a specific case that you've asked me to talk about. It's a case coming out of the Supreme Court of Canada decision from 2020, from last year. And it's a case that addresses private law remedies for wrongs under international law. So it's really quite all-encompassing and quite complicated. And it's an interesting case for a number of reasons, just on its facts alone. And also because of the manner in which the decision is written. In this case, our Supreme Court, the Canadian Supreme Court, which is comprised of 9 judges, was split in its decision 3 ways. So we see a decision of the majority, which was penned by Justice Abella, which Ankit mentioned, which is supported by 4 other judges. There was then there was a partial dissent by 2 judges, and a complete dissent by 2 other judges. So it goes to demonstrating how complicated the issues in this case are and how controversial the issues in this case are. Before I delve into the case in detail, just by way of an overview, the decision was a decision of the Supreme Court to not strike out a claim by certain former employees of the Bisha mine in Eritrea against a company called Nevsun Resources. And the case had been brought in British Columbia, the province of British Columbia in Canada. The plaintiffs in this case were 3 employees who had come to work at the mine through a subcontractor, but following their conscription into military service in Eritrea. And they are claiming damages for a number of things, but included in that array of causes of action were violations of customary international law prohibitions against forced labor, slavery, cruel, inhuman, and degrading treatment, and crimes against humanity. And that also led them to claim for breaches of domestic courts, torts such as conversion, battery, unlawful confinement, etc. Nevsun, the company defendant, had sought to have the claim struck out, arguing that it didn't merit a trial because the underlying conduct was an act of state. And so it wasn't justiciable for Canadian courts. That is, that it was not an issue that was properly litigated before the Canadian courts. And because customary international law could not form the basis of a domestic civil claim for damages. So that's that issue that Ankit's quote at the beginning goes to. The Supreme Court of Canada disagreed with Nevsun's argument in this case. So it sent the case back to the trial judge, and it's proceeding along that route now. That's the overview of the case. But I think it's useful to go through the case history and go through how it arrived at the Supreme Court in the first place. So as I mentioned, it wound its way up through the lower courts in the province of British Columbia. And so there were 3 main plaintiffs. And these were 3 individuals who were refugees in Canada. They're former Eritrean nationals. And they say that they were indefinitely conscripted through Eritrea's military service into a forced labor regime where they were required to work at the Bisha mine. And the respondent, Nevsun Resources, was an indirect 60% owner of the mine at issue. And that's how it became the respondent in this case. And when the case started, it started as a representative action. So the 3 main plaintiffs had sought to make the claim on behalf of 1,000 individuals who in total said that they had been compelled to work at the mine between 2008 and 2012. And they sought damages for those customary international law breaches that I'd already mentioned, in addition to other domestic torts. When it was faced with the claim, Nevsun brought a series of motions before the BC courts to have chunks of the claim thrown out on a preliminary basis, or to have chunks of the claim stayed. In essence, it sought to prevent the majority of the claim, or the majority of the international law aspects of the claim, from proceeding to trial. And it did this through two provisions in the BC procedural rules that are a bit particular to Canadian practice, but find mirror provisions in many other common law jurisdictions. So the first was referred to as Rule 21.8 of the BC Civil Procedure Rules. And that allows a party to apply to strike out a notice of civil claim on the grounds that it does not allege facts that, if taken to be true, would establish that the court had jurisdiction over the party in respect of the claim. And then it also brought its motion under Rule 9.5 of the BC courts. And in that case, the court it can strike out a pleading or a claim on the basis that it discloses no reasonable claim or defense. In essence, that the claim has no prospect of success and therefore should not take the court's time. And the Nevsun company relied on both of those rules to say that the act of state doctrine precludes domestic courts from assessing the sovereign acts of a foreign government. So that it made its objection on the basis of subject matter jurisdiction there. And then it also said, as regards the customary international law-based torts, that those have no reasonable prospect of success. So that was the basis on which the motions that led to the Supreme Court were founded in the first place. The first instance judge disagreed with Nevsun, and what he said was that the act of state doctrine forms a part of Canadian common law, even though it had never actually been applied there. Now let's back up and just go over very quickly what the act of state doctrine is or purports to be. Nevsun's argument basically was, look, the claimants in this case are arguing that they were forced through conscription, which was an act of the sovereign state of Eritrea, into a situation where their rights were compromised. But the underlying conduct there is of a state. And so what the court is being asked to do is to judge on the lawfulness of the state's conduct itself. And that's not permissible under the act of state doctrine. And so for that reason, the court doesn't have jurisdiction. That was the essence of its claim there. The reason this was a difficult issue for the BC court in the first place is because the act of state doctrine had never actually been recognized in Canadian common law. It's something that finds its genesis and development in early English law. And English law, of course, in Canada and in its genesis plays a significant role, but Canadian law then diverges from English law as the Canadian state gains independence from the British legal system. So the very question about whether the act of state doctrine formed a part of Canadian law was a fundamental question. And the judge says, look, it probably is a part of Canadian common law, but it doesn't apply here. And the reason it doesn't apply is because the act of state doctrine is not an absolute doctrine. There's not a complete prohibition on the courts of Canada for not pronouncing on the lawfulness of acts of foreign states. And that's because when you follow the jurisprudence about the act of state doctrine, both through the UK courts and through its development, or the way it's been described, at least in some Canadian jurisprudence, there's a recognition that states, the conduct of states is not completely sacrosanct. And when we look at cases where the courts have been asked, for instance, not to return an asylum claimant to his home country, for instance, the courts will not hesitate to say, we're not going to return this claimant to the home country because the home country does not follow the rule of law. or the home country has a suspect judicial system. So there are public policy exceptions to the active state doctrine, even if it did apply. And so given those exceptions, the judge said, look, I'm not in a position to say that the active state doctrine is a complete bar to these claims going ahead. And so I'm not going to throw it out on a preliminary basis for that reason. Then the judge moved to the second issue. The second issue was whether the idea that customary international law prohibitions on slavery, forced labor, inhuman treatment, crimes against humanity, whether those actually form the basis of an actionable tort in Canada, was something that the claimants could reasonably pursue. And again, the test here on this preliminary motion, again, this is not about the trial, but whether the claims could actually go ahead. And the test here was, is there a reasonable prospect of success? And the judge here said, look, customary international law forms a part of Canadian common law unless there is domestic legislation to the contrary. This is the principle of adoption. The idea is that customary international law applies universally. It has to by its very nature. And so the question, there's a novel question before the courts here. The question is, does customary international law give rise to a private law claim? And that is a novel question. It's one that the trial judge will have to struggle with. But I, as the judge on this preliminary motion, am not in a position to say that it's doomed to fail. And so I'm not going to grant Nevsun's motion to strike out the claim on that basis. That's the essence of the decision in the first instance. So Nevsun obviously appealed that decision, and it gets to the British Columbia Court of Appeal, which is the first instance court of appeal. And the analysis of the court at that state echoes the trial judge's analysis in some material ways. So again, the Court of Appeal says, look, the active state doctrine is not something that has ever been directly applied in Canadian courts. But when we look at British Columbian law, it has been implemented through legislation. And so it is a doctrine that can apply as a matter of law. But again, the Court of Appeal judge here says it does not apply in this case because what the Eritrean workers are doing here is not seeking to directly impugn the conduct of the Eritrean state, right? They're not bringing the Eritrean state to court in front of the BC courts. They're saying Nevsun was essentially complicit in the acts that were perpetrated by that they alleged were perpetrated by the Eritrean government. And then that forms the basis of the civil law remedy that they're seeking against Nevsun. And so for that reason, the active state doctrine doesn't apply. And then she also says, look, even if I'm wrong on that point, and it did apply, it's not a bar here because just as the first instance court judge said, there are exceptions to this doctrine. Those exceptions include public policy. And when we look at conduct, the alleged conduct of slavery, the alleged conduct of forced labor, these are areas of conduct in relation to which the public policy exception could apply. And so for that reason, she said on that point, the active state doctrine was not a bar to the claim going forward in the first place. And the Court of Appeal judge here noted something else, which is interesting and is important to this case. And it goes back to the fact that this was not a case about state immunity, right? The reason the active state doctrine was invoked by Nevsun is because Nevsun is not a state. And even if the underlying conduct is related to state conduct, Nevsun does not benefit from state immunity. And so that defense, which would apply if the Eritrean state, for instance, had been brought to court before the BC courts, was not in play here. And then the second issue was again addressed by the BC Court of Appeal judge here, was whether she should be throwing out the claims that were based on customary international law. And she said, look, this is a complicated issue, and it's a novel issue. But when we look at what's happening in the world outside of Canada, there is a development towards the conversion of public international and private international law. And domestic courts are globally becoming increasingly willing to address issues of public international law when it's appropriate. And she referred to this as the development of transnational law, this convergence of public and private international law. And so she said that question that comes out of this convergence about whether the Eritrean workers' claims were actionable as private law torts as a novel issue does not mean that they were doomed to fail in the Canadian courts. So it echoed very much what the trial or the first instance judge had said on the initial motion. So that's where the Court of Appeal came out. Nevsun was again not satisfied with that decision. It had appealed. The Supreme Court of Canada accepted the appeal, and that's what took us to the Supreme Court decision that now serves as the focus of the discussion before us. So there were two questions that were at the forefront of the case before the Supreme Court of Canada. The first one was whether the active state doctrine actually forms a part of Canadian common law. And then the second question was, can customary international law prohibitions against forced labor, slavery, cruel and inhuman and degrading treatment, and crimes against humanity ground a claim for damages under Canadian law? And it was not an easy decision for the court. And as I mentioned, we saw three decisions: the majority decision, a partial dissent, and then a total dissent coming out of the court. So let's go first to the majority decision. This is the decision penned by Justice Abella with 5 judges or 4 judges behind her. And the Supreme Court, like the first instance and appellate court before it, had to consider the viability of the Eritrean workers' claims as questions of law without delving into the factual evidence, right? So on this preliminary motion that the Nevsun had brought before the BC courts on the test before it requires the courts to accept the facts to be true as they are pleaded. So there's really a prohibition on delving into the evidence on the substantive merits of the claim. It's really a question of whether, in concept, these are claims that could be litigated or not. And that takes us to Justice Abella's decision, which Ankit referred to earlier, which was the question was whether a private law remedy for breaches of the international law norms alleged by the workers may be possible. That's the question. And she answered yes. And that view was rooted first in her rejection of the active state doctrine as a bar to liability under Canadian law. And to get to that conclusion, she did what the judges before her did too. She does a survey of the development of the doctrine through English law and how that doctrine worked its way into Canadian law. And she basically said, look, the active state doctrine is a doctrine under English law. It is not a doctrine under Canadian law. There are pieces of analysis that have weaved its way through Canadian jurisprudence. In that way, there are 2 notions that are encapsulated by the active state doctrine that exist in Canadian jurisprudence, but the doctrine itself does not. And so the 2 notions that she acknowledged exist in Canadian jurisprudence as a branch or as an offshoot of the active state doctrine was first on choice of law analysis about how when a domestic court will give effect in its own law to a rule of foreign law. So she says that's an area where the active state doctrine comes into place. If the Canadian court is faced with an issue about foreign law, it will conduct a choice of law analysis to determine how to properly implement the foreign law. And then the other offshoot is with the notion of judicial restraint. And she accepted that Canadian courts will refrain from adjudicating the transactions of foreign states. Canadian courts will not issue binding decisions about whether a foreign state acted unlawfully or not, whether under its own law or otherwise. So she acknowledged that those principles exist in Canadian law, but she said the doctrine itself does not exist. The existence of the doctrine is the basis on which Nevsun had sought to have the claim struck out. And so given that the doctrine doesn't exist, it can't be a bar to the claimant's claims from proceeding. And then her decision about allowing the Eritrean claimants to go ahead with their case was also rooted in three primary conclusions about customary international law. And her first conclusion was, look, these are issues of forced labor, slavery, cruel, inhuman, and degrading treatment, and crimes against humanity. These are part of customary international law. And then she says, going back to this theory of adoption, she says adoption applies in Canada. And what that means is that unless there is conflicting domestic legislation, customary international law automatically forms a part of Canadian domestic law. And there's no separate act needed to incorporate those principles into Canadian law. So as soon as we accept that the prohibitions on forced labor and slavery and cruel and inhuman treatment and crimes against humanity are customary international law, those prohibitions are also a part of Canadian law. And then she gets to the third primary conclusion underlying her decision. And this is one that is picked up by the other judges in dissent, and we'll get to that in a second. But she concludes that a corporation, even though it's a private actor, is not inherently excluded from liability for breaches of customary international law. So her first few premises were about customary international law and how it exists in Canadian law. And then she says, look, customary international law and international law in general is expanding in its scope, it's expanding in its application, and it's no longer just about the regulation of state-to-state conduct. It applies to private individuals. And so in that case, there's no inherent bar to it applying to corporations. And so given that it might apply to corporations, that's not a reason that the claim can't continue. So that becomes a very controversial statement that we'll get to in a second. But before she concludes, what then she also has to deal with is how the customary international law claims form the basis for an actual claim for civil damages, for a civil remedy in Canadian courts. And she acknowledges that this is a novel question. There's no tort of breach of customary international law recognized in Canadian jurisprudence. There's no tort for breach or for breach of the customary international law prohibition on slavery, for example, either. And so she says these are new issues, but there's no reason that this is not an issue that should go before the trial judge. And then it becomes an issue for the trial judge to determine whether these are torts that should now be recognized. And when we look at her decision on this point, she's really driven by a policy perspective, right? She says the common law is there to develop when it's necessary. That's where the trial judge is there to say, look, I think it's time for this tort to come into play. And she says, when we look at the issues in this case, there's customary international law that imposes rights. And so there must be a remedy. If we have rights, the law must provide a remedy. And that remedy does not currently exist, but it could exist. And then she also says, look, the torts in this case are about very atrocious behavior that offends the moral conscience of Canadian society or humanity. And so for that reason, even if torts that are currently recognized under domestic law, like battery or conversion, would deal with the underlying facts in principle, they're not the same because they don't address the really fundamental aspect of that's degrading about slavery or about forced labor. So she says there's a qualitative issue about the claimant's case that is not addressed by Canadian domestic private law at the moment. And that is an issue that the courts should be willing to address. And it's up to the trial judge to determine how he or she will address it. So that encapsulates the majority decision about why this claim should go ahead. Ankit, I can stop there if there are questions. Otherwise, I'm happy to go into the next, the first partial dissent opinion.
I don't see any questions here. Perhaps the dissent would ignite some.
Sure, absolutely. So then we get into the first dissent. And this is a dissent where the judges here agree with the majority about what the active state doctrine is and whether or not it would apply in Canadian law. They agree on that. Where they fundamentally disagree with the majority is about the use of customary international law to create domestic tort liability under Canadian law. And there are basically three areas of disagreement. They disagree on the content of international law. They disagree about how the doctrine of adoption, about how customary international law affects domestic law, how that operates. And they talk about the difference between the effect of international law on criminal law and on tort law. So it's that issue about the conversion of public international and private international law that forms the basis of the dissent. And when they get to explaining their dissent, they do it in two ways. And this is a bit of a bizarre aspect of this decision. They say that it's not clear whether the claimant's case, they say the way the claimant has presented its case is to suggest that there should be 4 new torts, and that those new torts would be the tort of slavery, the tort of forced labor, the tort of inhuman treatment, and the tort of crimes against humanity. But they say the way that the majority has dealt with this issue is to suggest that the claimants are actually only asking for 1 tort, and that the tort itself is the breach of customary international law. So those are kind of different ways to frame the underlying issue. And they say they think that the majority has actually misread the claimant's case. But they say, look, if that's what the majority thinks, it doesn't work, and we're going to explain to you why there cannot be a tort for breach of customary international law. We don't think that's actually what the claimants are asking for, but I'm going to tell you why that's not a thing. And then they say, well, what we do think the claimants are asking for are these 4 separate torts, but we'll explain to you again why we think that those should not be able to proceed. Okay, so they start with the first tort theory, the idea that the violation of customary international law is a tort on its own. And what they basically say is the premise of the majority's decision in this case, it requires a much too generous view about what adoption is and its implications for domestic law. And they say, look, it's not the job of the courts in Canada to turn international law into domestic law. That's the job of the legislature. And while there is the doctrine of adoption that says customary international law forms a part of Canadian law, the nitty-gritty of how that operates is not for the courts to determine, that's for the legislature to determine. So there's really a focus on the proper role of the courts versus the proper role of the legislature when it comes to determining the interaction between private law and customary international law. That's the first articulation of their disagreement with the majority. And then they also really disagree with the idea that corporations can be liable under customary international law. So remember that Justice Abella said, customary international law has gone beyond state-to-state conduct. It implicates private citizens, it implicates individuals and private actors, and so it may well implicate corporations, and there's no reason that it shouldn't, and so these cases should go ahead. And Justice Brown and Justice Rowe in this dissent look at that analysis, and they say, look, none of this is actually based in any developments of customary international law. It's all based on commentators, on scholarly articles that are writing about the normative direction in which customary international law should flow, but it's not a pronouncement on the actual state of customary international law. And they say, there is no basis for suggesting that corporate liability for human rights violations is recognized under customary international law. And if that's the case, then it cannot proceed in the Canadian courts. And they also disagree with the idea that a prohibition under customary international law can, without any act of legislature, turn into a basis for civil liability. And they identify what they see as kind of three paths to how a customary international law prohibition could give rise to civil liability. And that could be, for instance, if it was, if customary international law itself provided that a prohibition necessarily implicated a remedy. They say that's not the case. The other idea would be whether the prohibition, the specific prohibition itself implicated a liability rule, but they say that's not the case. There's nothing about the prohibition, for example, on slavery that necessarily implies a remedy that must exist under private law. And they say, you know, the doctrine of adoption, which translates international law into domestic law, doesn't go that extra step to translate a prohibition into a liability. And that goes back to their focus on the role of the legislature rather than the courts. They say, you know, as a matter of law, the existence of a liability under customary international law, the existence of a prohibition under customary international law does not necessarily imply a liability. So if there's going to be a liability, it's for the legislature to come in and impose that liability. And then they also go into why a tort remedy in this case is not necessary, because when we go back to Justice Abella's decision, there's a fundamental focus of hers on it's an access to justice point, right? She says, if there is a right, there has to be a remedy, and the tort that the claimants are pursuing is a natural remedy for them in this case, and so that's why it should be permitted to go ahead. And in this dissent, Justices Brown and Rowe disagree with that point, and they say, look, where there's a right, there must be a remedy, sure. But the remedy doesn't have to be a monetary remedy. There are any number of remedies. And just because there isn't a remedy in place under tort law doesn't mean that the legislature isn't in a position to create a remedy. So again, what they're saying is, yeah, you're saying that there's a right, but that doesn't mean that the remedy that the claimants are seeking is the remedy that they're entitled to be seeking, or that they should be seeking, or that we should permit them to be seeking without the legislator telling us to. And then they end the analysis really going back to the tenet of their approach, which is it's not the job of the courts to change the limits of international law, right? And it goes back to their theory on the limits of the theory of adoption. And they say if the courts want this approach, if Parliament wants the courts to say that customary international law gives rise to a private law remedy, then it's for Parliament to tell us, and then we as the courts will implement that. But as far as court-made law goes, it's well established in Canadian law that while the courts are there to create law, that only exists incrementally, and it only exists as a matter of necessity. And neither of those play out properly on the case that the claimants have put forward. So that's their analysis on what they say is the first approach, the idea of the tort in play being the tort of breach of customary international law. And then they go and attack the other point, the other approach, which they say is what the claimant's case actually is, the idea that the courts are being asked to create 4 new torts on the basis of customary international law principles. And in this case, their analysis is not really international law focused. They say, look, there's an established test for the recognition of new torts in Canadian law, and that test requires necessity. That test requires the absence of an existing remedy, and none of those requirements for the test have been made, right? So they say when you look at the tort about cruel and inhuman treatment, there is an existing remedy under domestic law, and that's the tort of battery. And when you look at the tort about crimes against humanity, that's covered by existing torts. And they say, look, it might be the case that the torts about slavery and forced labor are not exactly addressed by the torts currently in place in Canadian law. But it's not our job as the courts to create torts that would impugn the conduct of a foreign government. That's just not something they're willing for the courts to do. So again, you see that their decision is really based on a view about where the proper role of the courts lies, even if their analysis is not completely consistent in between the four torts that are being presented by the claimants. So that's the first dissent. Then there's a second dissent that takes issue with the idea that the act of state doctrine does not exist as a bar to the claims advanced by the claimants. And one of the issues that the courts, from the first instance court all the way to the Supreme Court, have really had to grapple with in this case was whether the act of state doctrine is really law under Canadian law or not. And we saw different approaches to that. And Justice Abella's majority decision says, look, it's not a part of Canadian law. In the second dissent, Justices Moldaver and Côté, they kind of say, look, forget whether you refer to it as the act of state doctrine or something else. The idea here is whether claims founded upon a foreign state's alleged breach of international law are justiciable. This is a justiciability issue. Is this an issue that is properly litigated before the courts? That's the question. Call it act of state doctrine, call it something else, call it whatever you will. But the answer to that question is no. Because when you look at the division of powers in the Canadian, provided by the Canadian Constitution, the dealing with international relations, diplomacy, is clearly something that is for the executive branch of the government to do. It is definitively not for the courts to do. And the claims that the Eritrean workers are presenting necessarily requires a pronouncement on whether the Eritrean government was acting unlawfully under international law. And that is taking the courts far beyond the line of their constitutional role. And for that reason, the claim is not justiciable. And they say, when you look at this claim in its at its core, the claimants are suing Nevsun, but they're suing Nevsun as a proxy for Eritrea. The claimants can't sue the state itself because of state immunity. And so what they've done is tried to find a way to sue the private company that they allege to have been complicit in the alleged acts and find a way to still impugn the underlying sovereign conduct. And that's the issue that this dissent is not willing for the courts to get embattled in. So that's that third dissent. And so, this case is really interesting for a number of reasons. In the first instance, it's interesting because it shows just how diverse the opinion is on the issues about the interaction between public international and private law. And how really, the premise that a judge starts with or a commentator starts with about the role of international law or the role of domestic law really affects the analysis with respect to those issues, right? And we saw that. So the majority opinion is driven by this concern for access to justice. And then you see that influencing how each of the substantive issues are addressed in turn, all the way to the end about why the tort of breach of international law, even if it's not currently recognized, should be recognized because of the fundamentally degrading nature of the conduct at issue. And then we see the second dissent is really concerned about the role of the courts and the judicial process. And so that becomes the main source of its disagreement with the majority decision on the customary international law related issues. On the third dissent, we also see a concern about the role of the courts. But in this case, it's from a constitutional perspective. It's about the division of powers in Canada. And so that's why it gets focused on the act of state analysis. So, the other reason that this case is really quite interesting is because in principle, we'll see how the case unrolls. It's currently still in process and will be for a number of years. But in principle, the court has opened the door to potential civil liability for companies under customary international law. And all of that together, civil liability for corporations under customary international law, that's a significant development. And whether it'll prompt similar cases is, of course, yet to be seen. I suspect that there are a number of plaintiff side counsel watching this closely to see where it goes, and a number of corporations out there looking to adjust their behavior in the event it ends up being taken up by the courts in favor of the claimants. But there is certainly a surge in foreign plaintiffs or plaintiffs bringing claims against companies in their home jurisdictions for alleged violations of human rights. And so, we've seen cases like that under the Alien Torts Claim Act in the US. And a lot of, not a lot, but there have been instances where the US courts have thrown out claims on the basis that corporate liability for human rights obligations is not something that the Alien Torts Claim Act is there to address. On the flip side, what we have seen in the UK in cases like the Vedanta Resources claim and others after it is the idea of courts in the home jurisdiction of a corporation being used by plaintiffs to advance claims for domestic torts, to suggest that the conduct of a company in a foreign jurisdiction gives rise to domestic tort liability under domestic law. So, this development has been happening for a long time, the idea of the intersection between foreign conduct and domestic liability. But what's particularly interesting about this Nevsun case is that it has taken it one step further, and it's about domestic liability for international law wrongs. So there are a lot of branches out there to keep watching. And so I think the message really is stay tuned, because there are a lot of developments to be had. And there's no certainty on any of them. But thank you very much for your time. It's really been an interesting case. It's not often that you get to just read one case and talk about it for so long. So I appreciate everybody's interest in this matter.
Well, thank you so much, ma'am. It's been a riveting discussion. Well, I hope it will be a riveting discussion, but it was a riveting talk nonetheless. We do have one question, and I also I'm on the same lines with it. Using public international law and private international law as a catalyst in domestic case law seems like a rather interesting proposition. But would it then also go on to become the redeemer for those who claim that international law is a creation by Western states? Would it then be a sword for those who strongly believe, are staunch supporters of the third world approach to international law, to say finally we can now utilize international law in our own domestic cases?
I mean, that's an interesting idea, but it goes back to the idea that every case is distinct on its own facts. And certainly that the criticism of international law, I practice international investment law, the criticism of the international investment law from that perspective of third world states is really pronounced these days. But the idea that the interaction between international law and private international law will necessarily give rise to that criticism, this criticism is not fair, I don't think. There's nothing that stops plaintiffs in India, for example, in principle. I don't know the law, but there's nothing that would stop a plaintiff in India in principle from advancing domestic law claims on the basis of international law domestically for domestic breaches. At the same time, in this case, this is a case that the Nevsun case is an example of how this is not about the domination of the West in terms of international law, because it's about individuals who were Eritrean, who are now refugees in Canada, who are seeking to impugn the corporation that they were previously working for. And so the claimants are not. This is not a case of the West against the developing world. So I think it can go both ways, and it really depends on the facts.
And I think it's even more interesting because of the use of a customary international law as opposed to a treaty. Because eventually, had it been a treaty, the state would have said that sorry, we are not a party to that treaty, and hence it's not applicable to us. So then they completely are devoid of any sort of
Right.
liability, right? But in Indian courts, or if there is an Indian law, usually in other cases as well, and in family law matters as well, if the country is not a signatory, the foreign court does not want to understand or appreciate the work that the Indian courts have done, and they go back to ground
Right.
zero and take it forward from there. But in Indian courts, the onus is really upon this kind of the sort of onus of providing some sort of legislative purpose is really high, and that is something that Indian courts are quite popular as well for.
Right.
We do have two questions. Mr. Utsav is asking over here, do you think that this judgment will act as a precedent, and can in near future we see such further claims in the Canadian courts, and I think in other courts as well?
Yeah, so I think people are waiting to see how the case itself develops, because what this case, I mean, this case as a decision of the Supreme Court of Canada is precedent in Canada for sure. But what it is precedent about is not that public internet or that customary international law necessarily creates liability under domestic law. It's precedent only for the principle that customary international law might create domestic civil liability. And that's why it sent the issue back to the trial court. So now it's for the courts to grapple with the really substantive issues about, well, is there actual civil liability? What does that civil liability look like? What is a tort that actually emerges? And are we willing to create a new tort? So as the case now substantively winds its way up, I think it will serve as a guide and as precedent for cases in the future. I think it's being closely watched on all sides.
But you also mentioned that this would go on for a couple of years. So in
Yes.
that sense, justice delayed perhaps would mean justice to some extent denied, because it's at the end of the day a human rights violation, and having some sort of a swift procedure perhaps would work in favor. Uh, there's also a live question which would like to be asked, and it
Sure.
perhaps ties on this as well. So I don't know who's asking it, but the floor is yours. Uh, but perhaps I'll read it because you haven't heard. When an investor state dispute is undergoing international arbitration, what remedies do the employees of the company who have suffered from human rights violations have?
So when it comes to investor state arbitration, the employees of the investor company or the local investment don't have any standing. Investment state arbitration is specifically about the investor, the foreign investor, and the state in which the investment has been made. And the issue is about whether the state has violated its treaty obligations to that particular investor. What we see and have seen over the last number of years is the use of human rights violations by the investor being invoked by states as a defense to their own liability. So what they will say, for example, is, yes, this investor invested in my state, and maybe I mistreated the investment, maybe I didn't. It doesn't matter, because when this investor invested in my state, that investor treated local employees improperly, committed a number of human rights violations, and having done so, it basically vitiated its entitlement to any protections under the treaty. So there being the idea of human rights violations or analogous corruption charges, stuff like that, is really becoming more and more pronounced in investment arbitration, but without any concrete implications for the employees, for the people on the ground themselves. It's really about the interaction between the rights of the investor and the obligations of the state.
Perhaps legislative intent in this circumstance would also be quite low, because at the end of the day, the corporation is responsible for creating jobs, and any sort of deterrent to a higher standard of any sort of law would act as a deterrent in that context, because it might mean more stringent views of value protection and also human rights protections and safeguards offered.
At the same time, treaties that are being that are being negotiated now, new generation investment treaties, states are much more attuned to these issues, and so often you'll see in new treaties the provisions of an obligation to abide by local human rights laws, for example, and so the obligation is being built in, and with a view to avoiding any dispute about whether an investor's protection is vitiated by abuse of human rights or not.
And there's another question here, and I think perhaps we can put it into a context as well with regards to the creation of stadiums and other facilities in Dubai with respect to the World Cup, and the violations of, at least the human rights violations, being caused to those persons who've been brought in from different countries, India being one of those, and the human rights standards which are not really being upheld. So then the question really becomes, what happens in such situations? Does political arm twisting really rule the roost, or is there another substitute which can be offered in terms of enforcement of treaties of human rights nature?
So the specifics of the example you've mentioned is not one I'm familiar with and not in a position to comment on. But I think, the idea that human rights issues are becoming more and more at the forefront of investor related issues, and raising issues of implicated in issues of diplomacy or implicated in issues of foreign investment is really hard to deny. And the manner in which they will get addressed in the future is developing. I think it really depends on the nature of the investors in play, their own position in the global political context, and different states have different views about human rights violations and what constitute human rights violations, and where they see their own role in regulating them. So it's really, there are a lot of factors in play.
Ma'am, any final thoughts which you would like to share? And I do have another question before you share your final thoughts. It's been addressed to me directly. I'll ask what the content is about. I'd like to know how you would react to the view put forth in the dissenting opinion that courts should not overstep their boundaries by making new law.
So, I don't think that the dissenting opinion says that courts should not make new law. It's well established in Canadian law. Common law is a principle of Canadian law. The courts do make new law. There's no doubt about that. The question is, when is it appropriate for the courts to make new law, and what would that new law look like? And the notion of the first dissent is, look, the courts are only there to make new law when it's necessary, and they should only do so incrementally. But it's not there for the courts to come in and overthrow existing principles of law through their decisions. And there are different views about whether that is the correct approach or not. I think there is a lot to be said for the courts being cautious about their role in the creation of new law. I think the primary role of the courts is to adjudicate the meaning of existing law. The common law allows them to create new law where fundamental principles are not being addressed by the existence of that law, and they can come in and fill in those holes. But the idea of caution by the judiciary when it comes to their ability to make new law, I think it is correct.
And I think the key word over there would perhaps be incrementally, or what I was perhaps thinking about is to tinker with the laws in terms of offering some sort of a solution on a case by case basis, as opposed to creating new legislation altogether.
And people have different views about what incremental means or not, right? So these are always up for debate.
we do have one question again. This is many countries deal with humanitarian issues in their domestic laws. So how does applying international law make a difference?
Well,
At least
I think,
in these circumstances. Of course,
yeah, so
employment is also a big issue.
well, I think you've hit the nail on the head with the premise of the question. Many countries deal with human rights issues in their domestic law. Many countries don't deal with human rights issues in their domestic law, and so it may be that this is a way for that to be addressed, where there is no domestic law to be grappled with. One of the reasons that the Eritrean claimants in this case are said to have brought the case before the courts in Canada is because they weren't going to get or even have the chance to pursue these kinds of claims before the courts in Eritrea. And so whether that's true or not, I'm not in a position to comment on. I don't know the specifics. But the idea that customary international law might assist in filling in holes in domestic contexts is an interesting one, and I think that's the issue that this case is being watched by a number of players globally is exactly about.
I think one must wait and watch. Perhaps hope justice.
Exactly.
I think justice should be provided sooner as opposed to later, because then the human rights violations and employment, the cleavage between rights and justice deepens even further.
Well, and this is in this case, this was on a preliminary motion, and so the court had to assume that the conduct did include human rights violations. But while the case is actually being tried, that's an issue that will actually have to be proven by the claimants that they were subject to slavery, that they were subject to human rights violations. So that's why this is. There are a number of facets to this case. The decision coming out of the Supreme Court was really about whether it can proceed as a matter of principle. The crux of the dispute, really, we're many years away from seeing the answer about.
Well, thank you so much, ma'am. It's been a riveting discussion and a riveting talk. Truly fruitful, and we are so grateful to you for joining us, sharing your thoughts with us. Thank you so much, ma'am. Any final words which you would like to share before we close?
I think I have
offering hope, because
no. I think I have said many words. You don't need to hear any more from me. But thank you very much for your invitation, and I really appreciate the questions from people who have been engaging with the issues. And thank you for your time. It's been a pleasure.
Thank you so much to everyone else who's joined us, taken our time from their busy schedules. We will now resume next week with a discussion by an Indian luminary of the legal fraternity, Mr. Subramaniam, who will be talking about a topic very similar to what we have today. This will also be a memorial lecture for Mr. Soleh Sorabji, who very recently passed away. We thank ma'am, and on behalf of the Jindal Society of International Law and the Center for UN Studies, and also the university, I thank everyone over here. Thank you so much.
Thank you very much.
Thank you so much, ma'am.